Let's look at the case updates for the 28th of January 2025. Two cases we're going to look at today: Snyders, Mputsue versus Elizabeth Conradi School, and Van Wyk versus Duze and another. Let's have a look at the relevant facts there. In the Snyders case, this case dealt with the capacity of a litigant for alleged mental health reasons. Was the litigant capable of litigating? Did she have capacity to litigate? The applicant sought an indefinite postponement of an application for leave to appeal because she was not mentally fit enough to conduct her own legal proceedings. She only had a medical certificate which was not complete and booked off work from November 2024 until an unspecified date. The certificate stated that the applicant suffered from bipolar disorder, rapid cycling, which was not explained, depression, generalized anxiety disorder, and panic disorder. The applicant alleged that she was entitled to legal representation under the provisions of Section 15 of the Mental Health Care Act 17 of 2002. The court found that despite her ongoing condition, she presented her case to the court cogently. Let's have a look at the first issue which is dealt with in this case, and that's a question of delays in the appeal process. The court reached the conclusion that it would be unduly burdensome on the respondent and severely prejudicial to it if an indefinite postponement was granted to the present application. Litigants who hold a judgment in their favour are entitled to expect that any proposed or contemplated appeal moves forward within a reasonable period. Even in extraordinary cases, a litigant could never expect an indefinite delay in an application for leave to appeal. And you'll remember that was being sought in this case, just go back one or two slides, was that she was looking for an indefinite postponement of the application for leave to appeal. And then the court accordingly refused the application for a postponement. The other principle that the case dealt with was new cases on appeal. Just one particularly interesting aspect that caught my attention. The court held that in motion proceedings, the affidavits form both the pleadings and the evidence. So that's fairly well understood principle, but there's authority for that proposition in this case. The present was not given an opportunity to deal with certain new, that should be the respondent, was not given an opportunity to deal with certain new factual defences. The court held that the applicant cannot make a new case out on appeal based on factual considerations which had not been fully explored in the court below. And the authority for that proposition is Ross and others. This was van der Meulen and another. So a party trying to make out a new case on appeal will be hit by the principle in Ross's case. And then in this case, what was interesting, that the court held that the same considerations would apply to applications for leave to appeal for the very same reasons. So a slight extension of the principle in Ross's case to applications for leave to appeal. Those are the two cases. This material will be put up with the topic for today in the training section, as well as the questions which flow from this video and from the training material, which will be placed, effectively be a word version of this slide demonstration. Thank you for your time. I'll see you in the next topics, which will probably be tomorrow.